Chapter V. Existing Creditors. SS 89. Classes of creditors, existing and subsequent. As pertaining to the subject matter of this treatise, creditors may be said to resolve themselves into two great classes or subdivisions, commonly named existing creditors and subsequent creditors. Existing creditors are those whose claims or demands against the debtor were in being in some form at the date of the alleged voluntary or fraudulent alienation. Subsequent creditors are those to whom the insolvent became indebted at a time subsequent to the alienation which is the subject of inquiry. The rights of these two classes of creditors are manifestly and necessarily different. The proofs in each case vary, and the measure of relief extended by the courts in particular instances is largely dependent upon the question as to which of these two classes or subdivisions the complaining creditor belongs. The difference, says Chancellor Williamson, between existing and subsequent debts, in reference to voluntary conveyances, is this: as to the former the fraud is an inference of law, but as to the latter there must be fraud in fact. This latter distinction, as we shall presently see, is not universally applied. Manifestly, if the debtor has made any secret reservation for his own benefit, the alienation may be overturned by either class of creditors. SS 90. Contingent creditors. It has been repeatedly adjudged that a party bound by a contract upon which he may become liable for the payment of money, although his liability be contingent, is a debtor within the meaning of the statute avoiding all grants made to hinder or delay creditors. It follows that the person to whom he is bound is a creditor. A wife is a creditor under 13 Alis. C5. In a case where her husband covenanted with trustees to pay her a sum of money after his death. A surety is a creditor from the time the obligation is entered into. And a person liable contingently as an accommodation endorser is a creditor before the dishonor of the note, and a warrantor, if at the date of the deed a paramount title was outstanding, is, from the time of the conveyance, a debtor to the warrantee. A municipal corporation is, upon the issuance to the proper officer of a tax warrant, a creditor within the statute. The date when the agreement or obligation came into existence governs in determining the complaining or attacking creditor's rights. As elsewhere shown, a person whose claim arises from a tort, such as libel or slander, is a creditor. The date the tort or injury was committed governs in determining the creditor's status, where the conveyance was made in pursuance of a fraudulent designed to defeat the judgment which might be recovered upon it. So a transfer to defeat a claim for deceit, for usury penalties, breach of promise to marry, seduction, bastardy, and assault and battery may be annulled, and a wife may attack alienations intended to defeat claims for alimony. In Pendleton v. Hughes, the defendants, at the date of the fraudulent alienation, had in their possession a 5-20 U.S. bond belonging to plaintiff which they afterward converted. The court held that plaintiff was equitably entitled to protection against the fraudulent transfer to the same extent as though the defendants had been indebted to her in that amount at the time of the fraudulent alienation. SS 91. Who are not creditors. In Baker v. Gilman, the court speaking by Johnson, J., said that the sole object of the statute in declaring conveyances void is to protect and prevent the defeat of lawful debts, claims, or demands, and not those which are unlawful, or trumped up, and which have no foundation in law or justice, and the verity of which is never established by any judgment, or by the assent of the person against whom they are made. As against claims and demands of the latter class, the statute does not forbid conveyances or assignments, nor declare them void. So a party who is not a bona fide creditor is not entitled to equitable relief on a creditor's bill. A pretended creditor whose claim is illegal, or void as against public policy, or barred by statute at law, or who is not concerned in the transfer, cannot support a creditor's action. A court of equity can only lend its aid to enforce a judgment which could be enforced at law. SS 92. Transfer of right to sue. It may be here observed that the right to avoid a fraudulent conveyance is not personal to the then existing creditor. His successors and assigns may enforce the right. Thus, the subsequent purchaser of a pre-existing note may attack a transfer. Campbell, J., says, no change in the ownership or the form of the debt affects the right incident to the debt to attack a conveyance fraudulent as to it. Davis, J., observed, the conveyance was void as against the person intended to be defrauded, and his heirs, successors, executors, administrators, and assigns if their actions, suits, debts, etc. were liable to be delayed or hindered thereby. SS 93. Voluntary alienations as to existing creditors. At first blush it would seem apparent that every voluntary alienation of a debtor's estate, aside from the question of intent, ought to be avoided as to existing creditors. The debtor's property is the fund upon which the creditor relied in extending the credit, and that, after the claim accrue, this fund should be depleted and pass into the hands of persons who did not pay value for it, is a palpable injustice to the creditor whose claim remains unpaid. Exactly how to accomplish substantial justice in such cases, and yet to give full scope and effect to the proper presumptions and rules of law, is not easily determined. Shall such a conveyance be declared prima facie or absolutely void? Some of the confusion and uncertainty which has been introduced into this subject in this country may be traced to the celebrated decision of Chancellor Kent in the widely known case of Reed v. Livingston, in which it was held that a voluntary marriage settlement after marriage was of itself void as to existing creditors. This case has been declared by an essayist to be the grandest monument of legal acumen and wide and varied erudition which New York has ever produced. And while it is conceded that the case was repudiated by the courts of the very state which gave it birth, it was asserted that unless indications are wholly delusive, the learned Chancellor was not more than a century in advance of his age. The English Court of Chancery in Freeman v. Pope substantially acknowledge the doctrine of this case and give the following emphatic and extreme illustration. If at the time of a voluntary settlement the settler had £100,000 and put £100 in the settlement, and a creditor for say £10 happened to be unpaid in consequence of the settler losing his money in the interval, that would be quite sufficient to set aside the voluntary settlement, and the doctrine of the case is unreservedly followed in many American cases. Salmon v. Bennett, a leading early case, created an exception to the rule set forth in Reed v. Livingston intends to uphold voluntary conveyances to relatives as distinguished from strangers, where actual fraud is not found. SS 94. Such conveyance is only presumptively fraudulent. If, however, the majority rule is to be applied in determining this conflict, or the cases are to be counted and not weighed, then it must be conceded that a voluntary alienation by a person who happens to be indebted at the time is only prima facie fraudulent. In Smith v. Vodges, Swain, J. said, in order to defeat a settlement made by a husband upon his wife, it must be intended to defraud existing creditors, or creditors whose rights are expected shortly to supervene, or creditors whose rights may and do so supervene, the settler purposing to throw the hazards of business in which he is about to engage upon others, instead of honestly holding his means subject to the chance of those adverse results to which all business enterprises are liable. The sentiment of these cases, says Mr. Freeman, is well expressed in Laro v. Wilmarth by Chief Justice Bigelow. We do not wish to be understood as giving our sanction to the doctrine that a voluntary conveyance by a father for the benefit of his child is per se fraudulent as to existing creditors, although shown not to have been fraudulent in fact, and is liable to be set aside, because the law conclusively presumes it to have been fraudulent, and shuts out all evidence to repel such presumption. The better doctrine seems to us to be that there is, as applicable to voluntary conveyances made on a meritorious consideration, as of blood and affection, no absolute presumption of fraud which entirely disregards the intent and purpose of the conveyance, if the grantor happened to be indebted at the time it was made, but that such a conveyance under such circumstances affords only prima facie, or presumptive evidence of fraud which may be rebutted and controlled. SS 95. Evidence of solvency. The Supreme Court of Maine regarded as established law that mere indebtedness is not sufficient to render a voluntary conveyance void. Consequently, it was said that a man, though indebted, may make a valid gift. Mere insolvency will not, of course, render a deed fraudulent, provided it was made with the sole view of paying a debt due to the grantee. As a general rule, if the donor is solvent and has, after making the gift, sufficient assets remaining to satisfy his creditors, the gift will be upheld. Subsequent insolvency will not generally render it invalid. In such cases, the creditor's trust fund cannot be said to have been depleted by the alienation. If their claims remain unsatisfied, it is due to some subsequently accruing cause. Judge Lowell, in Pratt v. Curtis derives the following propositions from the cases. A voluntary conveyance to a wife or child is not fraudulent per se, but it is a question of fact in each case whether a fraud was intended. Such a deed, made by one who is considerably indebted, is prima facie fraudulent, and the burden is on him to explain it. This he may do by showing that his intentions were innocent, and that he had abundant means, besides the property conveyed, to pay all his debts. The rule may be summed up to the effect that the gift, conveyance, or settlement will be upheld if it be reasonable, not disproportionate to the husband's means, taking into view his debts and situation, and clear of any intent, actual or constructive, to defraud creditors. Dunlap v. Hawkins embodies an important statement of the law upon this subject. The principle is asserted that a creditor cannot impeach a conveyance founded on natural love and affection, free from the imputation of fraud, when the grantor had, independent of the property granted, an ample fund to satisfy his creditors. Allen, J., in the course of the opinion, said, by proving the pecuniary circumstances and condition of the grantor, or him who pays for and procures a grant from others, his business and its risks and contingencies, his liabilities and obligations, absolute and contingent, and his resources and means of meeting and solving his obligations, and showing that he was neither insolvent nor contemplating insolvency, and that an inability to meet his obligations was not and could not reasonably be supposed to have been in the mind of the party, is the only way by which the presumption of fraud, arising from the fact that the conveyance is without a valuable consideration, can be repelled and overcome, except as the party making or procuring the grant may, if alive, testify to the absence of all intent to hinder, delay, or defraud creditors. And in Parrish v. Murphy, the court observed, to hold the settlement of a small amount by an individual in independent circumstances, in which, if known to the public, would not affect his credit, is fraudulent, would be a perversion of the statute. In Carpenter v. Rowe, the New York Court of Appeals held that, to invalidate a voluntary conveyance, belief by the debtor as to his insolvency was not absolutely necessary. It was sufficient if his solvency was contingent upon the stability of the market and the business in which he was engaged. In other words, a debtor has not the right to make voluntary alienations so as to leave himself in a condition in which he hazards the rights of creditors on the contingency of a fluctuating market. In Cole v. Tyler, the court say it was at one time the rule that a voluntary conveyance by one indebted at the time was fraudulent, as a matter of law, towards his creditors. No evidence was allowed to rebut the presumption of fraud. This rule was subsequently deemed to be too severe by the courts, and the less stringent rule was adopted that, while a conveyance by a person indebted was presumptively or prima facie fraudulent, the presumption might be rebutted by proof to the contrary. This presumption, however, is not to be overthrown by mere evidence of good intent, or generous impulses or feelings. It must be overcome by circumstances showing on their face that there could have been no bad intent, such as that the gift was a reasonable provision, and that the debtor still retained sufficient means to pay his debts. He can no more delay his creditors by such voluntary conveyance that he can actually defraud them.